you also have to understand this, that what if this were not the situation, would this contract still be in its place? Or would there be any other sort of contract which might come in place irrespective of the given fact, if irrespective of the given fact of the current situation? So let's just concentrate in the first point, the background research point. Let's just say, for example, we are dealing with a very common B2B agreement. At that point of time, when you're dealing with a B2B agreement, you're expected to understand the business. You're expected to understand the ongoings of the business in the given market. Third, you're also expected to understand if the transaction between the companies or the transaction between the individuals are big ticket transactions or a small ticket transaction. And I'll come back to you later on at a later stage as to why a big ticket transaction and a small ticket transactions consideration should be taken in its place before you get the homework done. Secondly, equip yourself with all the relevant facts and information pertinent to this contract. Now, when I say equip yourself with all the relevant facts and consideration, which it also means conducting a little bit of background research of the opposite party that you've been dealing with. So let's just say, for example, there's a company A and I am entering into a consultancy agreement with them. And my client is entering into a consultancy agreement with company A. Now, there are some issues which has evolved between the parties, which is very likely to evolve between the parties. And company A has come back to me with certain red line documents, or company has come back to me with a lot of pushback with how do you deal with circumstances in XYZ. So as a lawyer to my client, what 5 important things that I'll do? One is to do a very thorough research about the company, its mode of establishment, its understanding of how the business performs, do a little Google search, understand how the company performs. I mean, LinkedIn also plays a very, very important task during such circumstances. So I think LinkedIn could also be used as a resource tool. Secondly, ask this to your client as to under what circumstances did this contract came into consideration. Was there any other way through which you could have signed any other contract? Now, why would you ask this question is because your negotiations will highly depend upon what kind of contract you've been dealing with them. So if it's a B2B contract, or if it's a consultancy agreement, or if it is a mere simple NDA, your negotiation skills will have to be on point with regards to what exactly you're talking about at that point of contract, or what do you really want out of that agreement, or what do you really want your client to at least stay very, very firm about certain grounds. 3, I am going to go through the entire set of contract and understand what are the firm points that a company has really kept into consideration. Every contract that you go through, there is always going to be a hint of certain things which a company will never negotiate. There's always going to be a certain hint of something which the company are going to be very, very hell-bent towards it. They're going to come and tell you that, listen, no, we can't. It's going to be in layman's term or in legal term, it's also been termed as an emphatic no, which means a blanket ban no, which means we will never negotiate into this. These kind of emphatic no's are very commonly found in GDPR agreements, in data privacies, in data securities, wherein the liability to the opposite party and to the sub-processors processing the data is very high and very highly levied upon. 4th, I am going to ask what are the basic 5 bottom line things you do not want yourself to negotiate. And when will that thing come into consideration? When my client has understood what the contract looks like. Now, you may come up to me with a question saying that, ma'am, somebody else made the contract and I am negotiating it, or probably somebody else made the contract, I did not sit down and understand this, or probably why do I make my client understand for a contract which I never framed, or which I think could have been framed something better. This is going to help you narrow down your pushback or narrow down your level of idea to the opposite party to a lot of extent once you understand what your client has basic guidelines with them. They're not going to negotiate on the payment. They're not going to negotiate on the liability. They're not going to negotiate on the indemnity. They're not going to negotiate on any kind of wrong representation, or maybe even as a matter of fact, disputes, clauses like dispute resolution always has a negotiation back and forth. Indemnity and liability are exclusively famous, but dispute resolution has come up to be really, really new, and it's been forcing people to make sure that the dispute resolution is within their charm, is within something that is within their cost, it is within their area of fight. 5, and the last thing which I will do before sending it out is to ensure that my client agrees to the certain feedbacks, which I might leverage on behalf of my client. Now, I'll make you understand this with the form of an example. Let's just say the opposite party, for certain example, comes and tells me that, Hemal, we are okay with having, and we are okay with having 1 lakh rupees as a cost. And my client comes and says me that, listen, I am not going to pay anything more than 20,000 or 30,000. Your first fallback or your first pushback to the supplier is going to be 30,000. It stays between you and your client that the pushback might reach down to 20,000, pushback might go down to 10,000, but that is at the liberty of your client. You have to understand where your client draws a line. And when your client comes and tells you that, hey, well, we can't really go down below this, you will always have to quote up a little higher to the opposite party, because it gives them a space to leverage. It gives them, both the parties, a space to come to a common background. So in conclusion, these are the 5 important points which you will take into consideration before you are going through a negotiation or before you receive any kind of pushback or fallback from any kind of opposite parties. Now, let us talk about some important tricks and tips which you can use, and keep this in mind while you're dealing with the opposite party while the negotiation is on. Mind you, they are not exclusively psychological tricks. These are certain used tips and tricks which I learned from my seniors. Some of them which I learned and worked for me. You take your chances, but these are certain things.